Good evening, everybody.
Good evening. Good evening.
How's everybody doing?
Good.
I want to start off. Are there any questions at all? Okay. Now, one thing I want to go over and reiterate are exit tickets. The purpose of the exit ticket is I might hand out like a couple hundred exit tickets a week. So I am looking for, I have people who won't ask questions, or they just are too shy to participate. But this is another way for you to participate in class. So be very careful that you are answering the question that is asked on the exit ticket. Don't get in indiscriminately, just, psychobabble me with things on the exit ticket that have nothing to do with the class. It's class participation. So, I get all kinds of cute little notes, but you wanna make it applicable, to class in some kind of way. And so I just want people to be mindful of that. Some people, they're just, just nothing to do with class. So just be mindful about that. That is what you're being graded on your exit tickets. And then there are some times where I may get like 10 exit tickets that are saying the same thing. That's something that I then know I need to be addressing. It's feedback on certain little things that I definitely would want to correct or, make adjustments on. So by all means, if there's something, it's for all of that has to do with the class. Okay? All right, so we're going to move right on into our activity. There are no questions. You all, did you enjoy the activity that we had last week? Okay. It's not a high stress situation. Okay. All right, so we're going to move on to what I would call our next unit. That's what I want to call it. We're moving on. And so now we're going to talk about a subject that I think when it comes to business law, most encompasses some of the pitfalls, some of the things that cause a business to end up in a legal situation. Torts and products liability, one of the biggest ones. And then we skipped over to chapter 23 to just get a taste of the area that has to do with property, personal property and real property. Okay? And then I just want to make you mindful of Socrative if you want to participate in that. But then I'm going to move quickly through these. These are, for the most part, the same slides that we have already posted in our course content so that we can get into, because I will have one or two cases that we'll need to look at today. So this is just giving you an overview of a tort. It's a civil wrong where one party has acted or failed to act, and that an action or inaction causes a loss to be suffered by another party. The law provides a remedy for one who has suffered an injury or, in other words, a loss. And then in torts, we call the person who has committed the tort, the business who may get sued based on some type of a tortfeasor. So you'll see that word in your book. That's what it means, a tortfeasor. And so here we're coming back into that thing that I talked to you about in the beginning of the class. We're going to start folding in some concepts. So this book, this chapter is telling us that for the most part, tort law is going to be covered by that source of law, common law. And then it says, courts also look to rules articulated by the American Law Institute for guidance on applying the common law legal principles. And you'll see that mostly in what we call the restatement of torts. Okay, so then here we have categories of torts. We have our intentional torts. Okay, one in which the tortfeasor is willful in bringing about some type of event that causes a party some harm. And then we go into our negligence, which is for the most part what we're going to talk about today. Negligence. It's not necessarily intentional. A person didn't really intend to cause harm to a party, but in some instance something happened that caused harm to another party. Not necessarily intentional, but because of a business's negligence. And then your book talks about the strict liability torts, where these are such that if you're in the business of doing certain types of things, we're not going to be concerned with whether you necessarily intended to do it or not. These types of things, these are strict liability torts. You're going to probably be held for that type of a wrong, whether it's intended or not. And so these are our categories: intentional, negligence, and strict liability. We're going to talk about a kind of strict liability tort today, but if I ask you about categories of torts, don't be giving me all kinds of, where there is so and so, blah, blah, blah. Listen, I'm giving you right here on this slide. Boom, boom, boom. If I ask you to name 2 categories of tort, don't do a word salad. Intentional tort, negligence, or strict liability torts. These are our broad categories of torts that we're going to be focusing on in this class. And then your book gives you some examples of other intentional torts. So when we look at this broad category, see here, look, here are some intentional torts. Battery, intentional infliction of emotional distress. I mean, people, everybody, anything happens to them, this is going to be in that lawsuit. I'm distressed. It just caused me to be emotionally distressed. Trespass the land, trespass the chattel. When you see this word in your property chapter, chattel, a chattel, that's like a personal item, personal property item. That's not going to be real property. Okay? You can't put land, you just can't put it in your pocket and carry it away. This is trespass to chattel, like some type of a personal property item. Conversion, civil assault. So if I ask you, name 2 categories of torts, and you start going down here giving me battery and trespass the land, that's what y'all do. Y'all like to make things confusing. No. Let's keep it simple. Categories. Boom, boom, boom. If I ask you for 2 intentional torts, well, that's a different question. Those are types within the broad category of intentional torts right here. Okay? All right. So then here, I'm just going to give you a taste of negligence right now. And so these are our elements of negligence. Now, there could be some opportunity in the future. Who knows? I don't know if I'm going to do Apprentice, another edition of The Apprentice. I mean, my nerves were so shattered when I got home. I was just y'all had me just in a ball of just nerves. But if I were to, and I asked you for the elements of negligence, and people would be just scrambling around and turning around, and you over here helping everybody, and elements of negligence. Let's keep it simple, people. There are 4. breach, causation, and damages. That's how I see it. Now, this is how your book sees it. Your book, they'll say, this is what your book says. Duty, breach, causation in fact, proximate cause, and actual damages. That's fine if you, 1, 2, 3, 4, 5, 6, that's fine. But this is causation. Causation. Okay, so you have to have, the court is going to first ask, did the tortfeasor owe a duty? If there's no duty, if I don't owe you a duty, the fact that I did something and you got harmed, if I don't owe you a duty, then I'm sorry. That I can say I'm sorry to you, but the elements of negligence cannot be met. You have to have all of the elements. I like to make it simple, cause and effect, except for the breach of duty by the tortfeasor, would the injured party have suffered the damage, and then legal cause, approximate cause. Was there a link? Causation. Just let's make it simple. Was that thing that happened the cause of your injury? Causation. There has to be a link. If you come into my store, let's say that you were having problems with your ankle, but you came into my store and you slipped down. If it is in fact that there cannot be a straight line from you slipping down to cause that injury on your ankle, then you're not going to have causation. If your ankle was already hurt and I can prove that you had a pre-existing injury, it'll be hard for you to say that the slip caused your ankle injury. There has to be a direct line between the thing that caused the injury. Or if you came in and you slipped down, your right ankle was hurting already. And then you come into my store and you slip down and you cause an injury to your back. If you're complaining about the injury to your ankle, the injury to your ankle is not going to be the cause of the negligence that you're complaining about. You're complaining about the ankle. The ankle was already hurt when you came in. If you're complaining about the back, then we might have something. But there has to be a straight line. You have to have all of the elements. You have to have a duty owed by the tortfeasor, and then the tortfeasor will have to be found to have breached that duty, and then you need to have some type of proximate cause. And then if you slip down and cause an injury to your ankle, but you didn't go to the doctor, you have no damages whatsoever, then you have to have all the elements. So here are our elements of negligence. For my purpose, if I'm asking you a question about negligence, I'm going to be looking for these 4 elements: duty, breach duty, causation. I would like for you to be able to say proximate cause, and damages. So that's going to bring us to our case, one of our cases today that I want to talk to you about, because it's going to take us on a road to the end where we're going to end up. And this will provide just a little bit of foundation before we actually get there. So, So I want to talk to you about this line of cases, okay? This is going to be an example of what happens if you don't have all of the elements of negligence. So we're going to start off talking about a little bit of negligence. We're going to go way, way, way back. We're going to go back. This is how common law is made. 100 years of law, we're still citing this case today from 1891. Barrett versus Southern Pacific Company. Say that again?
26 years of law.
Oh, thank you. I was just...
I was curious.
I was just going to go 100 and just leave it there. But this is common law. That's how it's done. Okay? So this is an action. You're going to see the language of it may not be like the way we talk today, but this is an action to recover damages, personal injuries alleged to have been sustained by the plaintiff through the negligence of the defendant. Okay, the plaintiff recovered a judgment for $8,500. Back then, that was a lot of money. From the judgment, and in order denying the motion for new trial, so the plaintiff prevailed, and then the defendant filed a motion for new trial. That was denied. So then the defendant appealed. Okay? So procedurally, that's where we are. And so our case tells that it was shown up on the trial that the defendant maintained. This is how they talk about it. It was shown up on the trial that the defendant maintained a railroad turntable upon its premises in the town of Santa Ana, not that far from here. This table was about 150 yards from the defendant's depot and near its engine house, and the distant 72 feet from a public street, and it was not protected by any enclosure. Nor did the defendant employ any person whose special duty it was to guard it. It was provided with a latch and a slot, such as is common use on such tables to keep it from revolving. Has anybody ever heard of any of those terms? This is like a railroad or something like that. This is like olden days, okay? There were several families with small children residing within a quarter mile of the place of this location, and previous to the time when the defendant was hurt, children had frequently played around and upon it, but when observed by servants of the defendant, were never permitted to do so. So they were told, the children were told that they were supposed to, not play on that dangerous machinery. Okay, at the date of the plaintiff's injury, he was 8 years old. And he was younger, he was with his younger brother. And there were other boys playing on this toy, this is what they were thinking, giving them some oranges from the privilege of a ride, got up on it, and while it was being revolved, plaintiff's leg got caught between the turntable and rail up on the head blocks, and so severely injured that it had to be amputated. Okay, the defendant moved for a non-suit, which motion was denied. Okay, so all along the process, the defendant is trying to get out of this case. Okay, and the court is not having any of it. Okay, this ruling of the court and certain instructions given to the jury present the questions which arise upon this appeal. And so now we're at the Court of Appeals. And the appellate contends that it was not guilty of the negligence in thus maintaining upon its own premises for necessary use in conducting its business this turntable in question, and which was fastened in usual and customary manner of fastening such tables, that the plaintiff was wrongfully on its premises and therefore a trespasser. Okay, so what we need to know is that's important, because what do you need to have for negligence? Anybody? That first thing.
Breach.
The first thing.
Duty.
A duty. A duty. A duty. If you're trespassing on my land, then hey, go for it. You get hurt, go for it. But now, can we have this kind of a situation? These are children, okay? So the court was not, the trial court, they would not know. We not, no. Trespass, a child? No. Okay, so the defendant's like, I'm not afraid to say it. They were trespassers. And so that is the plaintiff's argument. I mean, the defendant's argument here. And so what they're trying to do is they're trying to attack that element of duty, because you have to meet all of the elements of negligence in order to prevail. And so here we go with the law. The court starts to look at the law. And the court says it is a maxim of the law that one must so use and enjoy his property as to interfere with the comfort and safety of others as little as possible, consistent with its proper use. And the failure to observe it is, in respect to those who have a right to invoke its protection, a breach of duty. Okay, that would be a breach of duty. And in the legal sense, constitutes negligence. So the court is going through this, they're laying down the foundation. And they say whether in any given case there has been such negligence upon the part of the owner of the property in the maintenance thereof of dangerous machinery is a question of fact, dependent upon the situation of the property and the attendant circumstances. So then the court is going to do some further analysis. Negligence in a legal sense is no more than this. It's not intentional, but it's just a failure to observe for the protection of the interest of other persons, the degree of care, precaution, and vigilance which the circumstances justly demand. So the court is just trying to lay the foundation here to see if this element is met or not. And so it's going through its analysis of the law. And the question of the defendant's negligence in this case was a matter to be decided by the jury in view of all the evidence and with reference to this general principle as to the duty of the defendant. If the defendant ought reasonably to have anticipated that leaving this turntable unguarded and exposed, an injury such as the plaintiff suffered was likely to occur, then it must be held to have anticipated it and was guilty of negligence. So it goes on. If is no answer to this to say that the child was a trespasser, okay? And if it had not intermeddled with the defendant's property, it would not have been hurt. And that the law imposes no duty upon the defendant to make his premises safe playing ground for children. Okay, well, it is a matter of common experience that children of tender ages, so here we go. We're getting into this common law theory that's being established here. Children of tender years are guided in their actions by childish instincts and are lacking in that discretion in those of more mature years. It is ordinarily sufficient to enable them to appreciate and avoid danger, and in proposition of this, lack of judgment on their part. The care which must be observed and toward them by others is increased because they are younger children and they don't understand. Okay? So it has been held in numerous cases to be an act of negligence to leave unguarded and exposed to the observation of little children dangerous and attractive machinery. This line of cases has come to be known as the attractive nuisance doctrine. In general, a landowner has no duty to protect its property from a trespasser. However, if you have these certain circumstances, a young child. You have left dangerous machinery. It is unguarded and exposed, and there is no warning. Then you're not going to be able to use the defense to say that there is no duty because the child is a trespasser. Yes, ma'am.
Wouldn't the duty be with the parents, though?
Yes. It would be, except for in this case. Here, the court is giving us everything we need to make the analysis. This is what it's saying. This is the common law. In numerous cases, it's negligence. You can't say you don't have any duty. If you leave unguarded and exposed to the observation of little children, dangerous, attractive machinery. It is unguarded and exposed, and there is no warning, then we're going to overlook the fact that your parents should have been watching you. This particular situation would be a situation where a person would not be able to get off on the lack of duty element. Okay? So we need to be able to look at this so that, and I have another example also. So the court does its analysis. The fact that the turntable was latched in the way such tables are usually fastened or according to usual custom of other railroads, although a matter of which the jury had a right to consider in passing upon the question whether the defendant exercised or he carried in the way that it maintained it, was not of itself conclusive proof of the fact, nor is it the liability of the defendant affected by the fact that the table was set in motion by the negligent act of other boys. None of that has any play on this because these factors are met. And so the court is going to affirm the lower court's ruling. All right? So then now we're finished with that, but now we need to move on to this other example right here in San Francisco. Because this is going to bring us within the purview of the case that we're going to end up talking about today. This is Peters versus Bowman. This happened in 1896. This is a different kind of case, however. So we're going to see the difference, okay? This was an action brought by the plaintiff to recover damages for the death of his infant son. He's calling him an infant. I believe he was like 8 years old, too. But, okay, infant son.
That's not what infant means at all. Infant means that a person, oh my God.
Okay, I will continue to look at the facts and make sure that what I'm saying is, I feel like he was not an infant in it, but in 1896, these are the types of terms that they kind of use. His infant son, who was drowned in a pond of water up on a lot of land owned by the defendant, Mr. Bowman. The jury returned a verdict for the defendant, and the plaintiff appealed. Okay. The facts are practically undisputed and may be stated briefly that the defendant owned this lot in question and resided on it for several years up until 1889 in San Francisco. Okay. In its natural condition, the surface water which came from the lot flowed off and through a gully across the street, Ashbury Street, over which there was a small bridge, and it emptied into a pond a couple of blocks away. However, thanks to the city of San Francisco, it graded this street and it put up an embankment along the street and across the gully, and on the westerly side, of this lot to the height of 8 or 10 feet. So then this prevented that water from flowing off the guy's land. And so the water, on this account, the defendant removed, so the water would accumulate on his property and create a pond. So he had to move, so he took his house and moved it to another county. Okay. So I do want you to be mindful. Let me just stop right here, because I do want you to be mindful of some, well, I'm going to keep going through this and then we'll come back and talk about it and I'll ask you a question about it later. But he took his house, took it off the land and moved it elsewhere. And so from that time until 1894, when the boy was drowned, the surface water being stopped by the embankment would, during the rainy season, form a pond on the land. And so, and it would disappear in the dry season. Okay, so the defendant did nothing to create this pond, or he did nothing to prevent it from flowing away. And so far as he was concerned, it may be considered a natural pond. Okay, the lot, it was not enclosed by a fence or otherwise. And after the defendant removed his residence, he did not often visit the lot and did not give permission to or invite anyone to go up on the lot. But children did visit it, and they played up on the pond. And it says, and he must be presumed to have known that fact, because he drove children away once, and a policeman did the same several times. So he knew that children would visit the pond on his land. The plaintiff knew of the existence of the pond. The plaintiff, the father of the deceased child, knew of the existence of the pond and knew his son knew of it. And he never, this is in quotes, see this right here? That's in quotes. The court put that in quotes. That came from some type of testimony, I'm assuming. But that's all I can do, is assume. But they put that in quotes. He never told him not to go rafting on the pond. The son was 11 years old. She's not having this at all. He was an infant. I just, these are just little cautionary tales that, I like to, let people know about. Okay, and so the exceptions to the general rule are instances where the owner maintains we're gonna go over to our common law that we just learned about, maintains on his land something in the matter of a trap or other concealed danger known to him, and as to which he has given no warning to others, and instances where he has had something in the nature of a wanton injury to the trespasser, or where the owner had set sprinklers. These are other situations. If you know that your neighbor likes to come sneaking over to your property, and you say, you know what, I'm gonna set a trap for him tonight with his sneaky self. That's now don't do that, because you can't do that. Okay?
It's a big bear trap.
You're just a big bear trap. No, you can't do that. Yes, ma'am.
Is that when people have the warning dog signs? Or, like, if somebody broke into my yard and my dog attacked him, they can, I'm saying, if that were to happen.
Well, that's a dog. That's different. If you go and you say, my neighbor with his sneaky self, let him come over here tonight. I'm going to set a gun that has
triple wire or something.
What was that thing that they had with the guy in Las Vegas? A bump stop trap on it, where if he come in and slip over the trip wire, it'll just shoot 200 bullets into him. No. That's what I'm talking about. Hey, you can have a dog. I mean,
So you wouldn't be liable?
No. But if you set a trap now, a dog, that's just, it's home security. But if you set a trap, like, you know, a person, if I'm sneaking onto your property, I can expect, even if you don't have a sign, I need to think, okay, you know, a dog is gonna bark, you know,
Right.
give me some kind of, I wouldn't, but if I'm sneaking on there and I slip across a tripwire and then 200 bullets come at me because you set a trap, no, you can't do that. That's something to be, okay. Don't do that.
So Home Alone, in the movie Home Alone, they
Okay.
could have sued Macaulay Culkin.
Okay, well,
You know the movie Home Alone where he sets up all the traps to catch the kidnappers?
okay, but what kind of traps?
Oh,
Okay,
they
are
were
these
bad.
deadly?
Yeah.
No,
They should have
I
been.
mean,
Yeah,
They should have died.
They
It was a
should have
comedy.
died, like the hot iron
They
and.
should
Yeah.
have.
Falling
They
downstairs.
electrocuted them, set them on fire.
A lot of head injuries.
That's
Uh,
pretty gnarly.
Well,
Hospital bills or.
But he's a minor, so how can you sue a
maybe,
minor?
right.
He didn't own the property.
He could say terrified, you know.
Maybe.
He could say, I felt threatened.
Yeah,
Yeah, he was a minor,
I like the
minor didn't own the
Maybe.
property. So I don't know.
yes, maybe. I mean, you know, there are certain things that you just can't go into, just set a trap.
In Texas, if you just walk on their property, they can shoot you. That's what I heard, but that's the rumor.
Yeah, but that's not a
Yeah, but there's
trap.
signs that.
Okay.
There's
You don't
signs
need a
that-
sign. If you come over to my house, that's not a trap. You come over to my
Right,
house,
like I didn't premeditate.
open the
No,
door.
he's talking about Texas. And I said, no, there's signs posted. Trespassers will be shot on sight.
Okay, well, that's
They-
great.
They give you fair warning.
You might need it though.
Yeah, that's great, but I'm not gonna leave a sign in that case. Come over.
Please.
Come over. I got a little something for you. It's not gonna be a trap. You should expect that if you come over to my house, just expect that. Okay, all right, and the general rule applies to children. This is what they're saying. The general rule applies to children as well as adults, with some exceptions hereinafter noted. The rule is that ordinarily, the owner of premises owes no duty of immunities to trespassers, okay? Plaintiff seeks to take this case out of the principle above stated, and this plaintiff is now trying to use common law. The rule of now, what we call the rule of the turntable case.
Still the 1891 case.
Yes. Yes. They're saying, oh, well, hold on, Judge. Let me cite a case. And so the judge says that rule, which is a marked exception to the general principle, has been approved in many states, and by the way, also in this state, it must be taken as approved in this state by the decision of this court in Barrett v. Southern, blah, 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 and others cited by the appellant. But the rule of the turntable case is an exception to the general rule principle that the owner of land is under no legal duty to keep it in a safe condition for others than those whom he invites there, and that the trespasser take risk of the injuries from ordinary visible causes, and it should be carried beyond the class of cases to which it had been applied. And the cases to which the rule has been applied so far, as our attention has been called to them, are nearly all cases where the owner of the land had erected on it dangerous machinery. Okay? So we got to go back and check our facts. Did our guy erect dangerous machinery? He did not. It was a natural pond. Okay? The consequences of meddling in which was not supposed to be fully comprehended by the infant mind. The 11-year-old infant mind. It is not contended by appellants that the rule of the turntable case has ever been applied to facts like these. His contention is that the reasoning and philosophy of the rule ought to extend to these types of facts. Well, see, we can't do that. That's like me. If I go into with the judge and I have a case and it's not on point, the judge will be like, well, what? Hello? What they got to do? that has nothing to do, that doesn't match with these facts. This is how we apply the common law. What I do is I have to go in my book, I have to find a case that's like my case. If you come in there with a case that's not like your case, the judge is going to run you out of there. Okay, so what this court is saying is the rule is that a body of water, either standing as in ponds and lakes, or running as in rivers and creeks, or ebbing and flowing as on the shores of the seas and bays, it's almost like a song, is a natural object. The danger of drowning in it is an apparent open danger, the knowledge of which is common to all, and there is no just view consistent with recognized rights of property owners, which would compel one owning land upon which such water, a part of it, stands or flows, to fill it up or try to surround it by impenetrable wall. And the court goes on to say that no case has been cited where damages have been successfully recovered for the death of a child drowned in a pond on private premises who had gone there without invitation. While it has been repeatedly held that in such a case no damages can be recovered. The single question presented by the record is whether the owner of a vacant lot upon which it is situated a pond of water or a dangerous excavation is required to fence it or otherwise ensure the safety of strangers, old or young, who may go up on said premises, not by invitation, express or implied, but for the purpose of amusement or from motives of curiosity. Independent of statute, no such liability exists, says the court. So see here how we apply the facts. We have one case where if the owner on his own erects a dangerous machinery on the property, he's not going to be able to say there's no duty. But he's not going to be able to say there's no duty. But if you have a landowner who has just a natural body of water, he has done nothing, he can say there is no duty. He has no duty to guard it, to try to, he was going to put a guard on it, or is he going, it's a pond, is he going to try to enclose it? No. And so these are the differences that we'll see here when we're applying the elements.
Erected a pool. That.
But see, we're not talking about a pool.
Okay.
Yet.
Okay.
Okay? Just be patient if you can. I don't know. You might miss it. Okay? Was the duty of the defendant to fence or guard the hole, which it does not appear he made or caused to be made? I mean, the court just went, so this is our rule now. Okay? So now this is also going to be added to the body of common law. So in the end, the fact of the matter is that under certain circumstances, you will be able to indicate to the court that the element of duty is not met. But in others, if you go and you put something dangerous, you have something dangerous on your property, you know that children are in the area, you better make sure that you fence that thing, put a guard on it, put a note up at the beginning of the subdivision telling parents, beware, dangerous machinery. You know, you better make sure that you have all of your boxes checked, because if you get sued, that element of duty, if you can meet all the elements, then you're going to be found to be negligent as that business owner. Okay, so let's move on. So that is the attractive nuisance doctrine. The attractive nuisance doctrine, which acts as an exception to negligence, which will, in whatever case, rule out the element of duty. If there is no duty, then you cannot breach a duty. And so along the way, I want to stop through our chapter 23 and talk to you about tangible, what the book calls tangible property, real property and personal property. And then, so here, right here in your book, it talks about tangible property, of course, is property that can be touched and physically possessed. There are two forms, personal and real. The book talks about the characteristics of personal property is both tangible and movable. So now, the man took his house, he picked it up and he moved that house. Is that tangible or real property?
Tangible.
Personal or
Is it
property?
personal or real property? I'm
Personal.
sorry. At the moment that the house is affixed to the land, is real property. When he picked that house up and moved it, it became personal property.
So a house is technically real property?
A house is real property. A house affixed to the land, and any appurtenances that are also affixed to the land become a part of the real property. If you pick that house up, the minute you pick that house up and move it, it becomes personal property until
Relocate it.
it's relocated. And I wanted to make you mindful of that little distinction. And your book talks about some real property ownership interests. I wanted to also just dibble and dabble, give you some lay of the land on those. And your fee simple. So in this particular case, both of those were probably going to be what we call fee simple. Fee simple, probably absolute owners of that property. Okay.
So I have a question.
Yes, ma'am.
So is land considered property and the house considered real property? Are they considered two separate entities even though the house is on the property?
The house on the property, as long as the house is on the property, is real property.
It's one.
The land also is definitely real property. There may be some oil or whatever flowing underneath the property, that's a part of the real property. And so your book talks about leaseholds, easements, zoning, all these different kinds of things. You can have an easement, an express easement, or there can be an easement by implication. I feel like when the city put the embankment, even though it was not on the guy's property, it created an easement by implication. He could not use that property. The city put the embankment up for whatever reason they did. It landlocked his property and made it unusable. They needed to do that, and by implication, it really it created an easement. Even on his property, even though the actual embankment was not even on his property. So these are things that that business owners should be made aware of. When you go and get a piece of property, you want to look around, make sure that somebody else building something may not throw up, may not obstruct a view that you may have for a business purpose or whatever the case may be. But this can create an easement by implication. And then again, we talked about the personal property. I just wanted to, make you aware, because when it's saying in a business context, goods, vehicles, inventory, equipment for business operations, such as computers, are all examples of personal property. A house, if moved, could also be personal property, because any property that's movable is going to be personal property. Yes, ma'am.
So one of the Learn Smart questions addressed this. So what if, my parents own their house, it's not their personal property?
Your parents own their house?
Yes.
Yeah, and the house is on the land. Yeah, that's real property.
Okay. All right.
Okay, so ask this question again.
Because the Learn Smart question
Okay.
asked, each of the following is personal property except car, house, computer business inventory, and I thought business inventory would be.
Okay, well, the house is probably not unless they give you some more facts.
Okay.
If they say I took the house and moved it, if they say I took the house and moved it, then that's not gonna be personal property. I mean, that's not. If they took the house and moved it, it would be personal property. You would need those facts. Did the question give you those facts?
No.
No.
And so, is that because like most people don't own their houses?
No, it's because people don't move houses. People don't move houses
They're
every
really
day.
heavy.
Huh?
They're really heavy.
Yeah. I mean, you don't just move a house. You see, this is an unusual thing here that happened with this guy.
What if it
So
was a
normally,
trailer?
huh? Say this again.
Like you know how some people like they'll buy a plot of land or they'll
Yes.
move their trailer to somebody
Yes.
else's plot of
Yes.
land.
When
so
they
your trailer will be able
when
to
they move it, it's personal property.
But if it's on somebody else, like if I just like my cousin has 2 acres, so I go put my trailer on his property, is that my personal property now?
Once
because
you
it's not on
put
land?
that house, be careful where you put your house. Once you put your house on somebody else's real property, it becomes their real property. Yes, ma'am.
That's why if you ever own a mobile home and you try to take out a home equity line of credit, it's not considered real, I'm a banker, real property, so the equity, you don't gain equity on a mobile home.
Is that why they're not like they don't usually give out loans?
Mortgages and stuff on a mobile home.
right for
Because
mobile
the
homes.
proper, it's not real property how you would get a mortgage loan for that.
Yeah, it's like a leased vehicle.
Yeah, kind of.
Yes. Right. And so it can be moved at any time. I mean, you know, when you get ready to move a house, I mean, a house, you're going to have, people are going to know about that. Okay. Yeah. Okay. So when that question is being asked, it's because there are people who they don't, see, I don't write textbooks. So there are people who they don't bring in real life examples like this is a situation where somebody moved a house. That's not something, when they say in a house, they're really meaning a house that's attached to the land. They're really meaning real property.
Okay.
They didn't know about this case.
Yeah, I think the question was just pretty fair, so.
Yeah. Yeah, they didn't know about this. Okay. And so then we talk about products liability. We're going back into our torts. I just wanted to stop along the way and give you some flavor from the property part of the lecture as well. But now we're going to go back to our tort part of the class when we're talking about products liability, and your book is talking about in a products liability case, the injured party may pursue a legal remedy against the seller, and they're under 3 legal theories. Okay, see this here? Okay, so products liability has 3 legal theories: negligence, warranty, and strict liability. This can be very confusing when I'm asking you about categories of torts. Don't get slipped up. Okay? Products liability is another type of tort. And there are 3 theories upon which you can sustain this type of a cause of action: by negligence, by way of warranty, or strict liability. Okay, and then your book talks about the negligence piece we've already talked about, and so I'm going to move through that, and we've already talked about these elements. And then the book talks about warranty laws are important for the protection of purchasers because they impose liability even in the absence of negligence. Okay? And then your strict liability, the seller is engaged in the business of selling such a product, a gun, or whatever the case may be. The product is expected to and does reach the user or consumer without a substantial change in the condition in which it is sold. Strict liability is a concept rooted in the notion that the general public benefits when liability is imposed on those who engage in certain activities that result in harm to another party, even if the activities were undertaken in the most careful manner possible, and maybe even without negligence. But it's a type of it's such a, what would probably be in some instance a dangerous type of a situation that the strict liability tort is going to be applicable. And then your book talks about section 402 from the Restatement of Torts. Strict liability is imposed on the seller even though the seller has exercised all possible care in preparation and sale of the product, and the user or the consumer has not bought the product from or entered into any contractual relationship with the seller. So this is strict liability. And then design or manufacturing defects are types of strict liability, inadequate warnings, improper packaging, unavoidable or unsafe products. But then on the other hand, the seller can come back and have some defenses like we talked about before with negligence, where if it were a negligent strict liability imposition, if they're able to create a situation where they can show that there's no duty, then they will be able to get out of that situation. But then we're going to look at some other cases. And then if it comes up that the plaintiff assumed the risk, then it may be that the seller may not be held liable for that strict liability as well. And so we're going to look at this. I wanted to bring us through that line of cases and bring us now to a swimming pool situation. And so this is Marisol Maldonado versus Walmart. Okay? Check my time. Okay, just have a few minutes. And so I'm going to look at the docket sheet just a little bit in this case. Here's the docket sheet right here. Okay. So, just so that we can look at some of the things that we have encountered before. Here are all the parties here. So this is Marisol Maldonado and all of the different attorneys. You can see what this case is. This case is in Pennsylvania. Now, what we need to know is that everybody knows that Walmart is based in Arkansas. This happened in Pennsylvania. Walmart is based in Arkansas. Let me just blow it up just a little. So what happens is Miss Marisol brings this case in Pennsylvania, and one of the defendants removed this case to federal court based on jurisdiction. What kind? Personal? I'm looking for something. I'm looking for something. Pennsylvania. Walmart is in Arkansas.
State.
Okay, but what do we call that? What kind of jurisdiction? You're going to have what when you go to federal court? Either one or the other.
Federal question.
Or what?
Over $75,000.
Or diversity of citizenship. So one of the parties removed the case to federal court. It was not Walmart. It was one of the other defendants, the pool manufacturer, the alleged pool manufacturer. because it turns out, well, let me go this. I'm just going to tell you. It turns out that soon after the incident, the pool was thrown out. They really didn't know who the manufacturer of the pool was. So they had to try to figure out who it was. And turns out that it was possible that it was Intex. And so Intex, once they were brought into the case, they removed the case to federal court. Okay? And then at some point in the litigation, Walmart then files a motion for summary judgment. They're saying there is no need, Judge, for us to waste our time going to a jury trial. And so we're going to look at this is Walmart's motion for summary judgment. I'm just going to take a brief look at it. Okay, and so they lay out the facts here. And so here we have the plaintiff, Marisol Maldonado. She filed this action alleging that the plaintiff's decedent Jonathan Delgado, which is her son, who was 15 months old, sustained personal injuries on July 28, 2006, when he climbed into an inflatable swimming pool in his aunt's backyard. This is not Miss Maldonado's pool. This is a pool over at her sister's house. And said injuries led to the decedent's death. The case was removed from the state court. And the plaintiff is alleging that a defective product, namely the inflatable pool, combined with the negligence of the defendants to cause the deceased's injury and death. And then the plaintiff, the inflatable swimming pool was purchased in June of 2005 at Walmart in Philadelphia, Pennsylvania. In support of her strict liability claim, so she really claims negligence and strict liability. She alleges various defects. Inter alia, that the pool contained dangerous characteristics. The pool was dangerously defective in that it allowed access and entry from the exterior wall surfaces. The pool lacked adequate warnings and instructions. The pool was properly tested, and the pool was sold without provisions for a fence, door, alarm, and rigid supports. An inflatable pool. It didn't have a door. It didn't have a fence.
Or an alarm.
Or an alarm. Okay, now her child really was an infant.
Yeah.
Okay, you agree. Okay, thank you. In support of her negligence claim, plaintiff alleges that the defendant breached his duty by selling an unsafe product. Walmart sold an unsafe product. They failed to incorporate proper instructions, and they failed to properly warn and misleading customers. Okay. Okay, so here are the undisputed facts. And this is important, so I went ahead and included it. That the plaintiff, these are the people that were at the house. Okay, plaintiff was a guest at the home for Sister Diane. These are the people that are present. The plaintiff was there. Diane was there, Diane's husband, Bob, the plaintiff's son, Gabrielle, the plaintiff's son, Danny, the plaintiff's 15-month-old son, Jonathan, who died, and plaintiff's friend, Tanya. Okay, these are the people that are at the house. After the above group left to get pizza, plaintiff went into the kitchen where Danny, Jonathan, and Tanya. So Marisol, Danny, Jonathan, and Tanya were left at the house. The kitchen has a back door and it opens into the backyard where an inflatable pool was located. Okay, the plaintiff had to use the restroom. Okay, she says to Tanya, keep an eye on the kids. At that point, Danny made his way into the backyard. Plaintiff is not sure whether Tanya acknowledged or responded to this request. 15-month-old.
Yeah.
She wasn't sure whether Tanya heard her when she said she was going to the bathroom. So she went upstairs, not over in the next room. She went upstairs to the bathroom, and when she heard a splash, she looked out the window but did not see anything. You have a problem? Okay, okay. Go ahead and tell me what's your problem so I can.
Okay, first of all, it's a 15-month-old baby.
Okay.
Okay, and there is a minor watching a minor with a back door that's unlocked. I'm sorry.
So
I have
that's
an 8-year-old
Walmart?
child. I have a problem. No, Walmart's probably not. I have the same bloody pool. There's no way my 15-month-old child could have crawled into that pool, let alone got into it by himself. Couldn't have.
Oh,
It's
Lord.
too tall. There's
Oh,
no
the-
way.
Well, what about the ladder?
Drowned his brother.
How did they get in the pool? No.
What?
How did they get in the pool?
Okay, what about the ladder?
Okay, if they had to put the ladder back in the pool, where was the ladder to begin with? How'd the kid get in the pool?
We don't know, but hold on.
Yeah, there's a problem.
Okay.
Because there's no way. I mean, even at 8, my daughter cannot climb in that pool.
So I could see you be filing a lawsuit, wouldn't you?
No, I'd be beating up the sister. I'm sorry. It's
Are you
her
gonna
fault.
It wasn't the sister, it was
Well, how much money
Oh,
does...
Tiny, no, because the sister left a minor in charge of a minor and went upstairs to the
the sister
bathroom.
left.
Oh, the sister
The
left?
sister
sister
left,
left.
the mom left Tanya in charge. Well,
Oh,
the mom,
God. Yeah, you're right. I'd be beating
her
up
mom
Tanya.
kind of said it.
Okay, well, how much money do you think Tanya has?
Oh, no, it would not be that.
She's saying get the money, I'm just gonna beat her up.
No, eye for an eye kind of thing.
Oh, okay.
My kid's dead because you weren't paying attention? Yeah.
Well,
Houston, we have a problem.
Well, it gets worse.
well, she said she told Tanya, but she wasn't sure Tanya heard her.
No. I'm gonna leave my 15-month-old child in charge. I'm gonna make sure that person's, do you understand me? Do we have a connection here, you know?
Not everybody's really smart.
No, you're right.
Anyone.
I'm sorry, you're right.
Okay.
Yeah, I know.
So, you see, we have a problem. We still have a problem here.
Yeah, we do.
Okay, all right, so...
But my problem's not with Walmart.
Okay. Oh, good. I'm glad. I wouldn't say that out loud. If, you know...
No, I'm just saying, well, yeah.
Marisol, because I'm going to let you use Marisol.
Yeah,
Since
yeah.
you saw
Oh, great.
all of the dangers involved in the pool...
Let me backslap some people then. No,
Okay, so this is Mr. Rooney. This is Marisol's attorney. He's saying all the dangers involved in the pool and the ability of the toddler to get into the pool without being noticed. So the judge is like, oh, you know, why are y'all here? And the court says, my recollection was that, okay, well, I need to go back. Okay, because this is where the judge he cannot understand what's going on. Okay, the court. My recollection was that he read the instructions. He's talking about the husband, Bob, with respect to the setup of the ladder. I highlight that because we cannot discount the fact that there was a ladder. I just want to make that soft reminder. Okay, the court is like, it's tragic. It goes beyond the pale with respect to the tragedy. I understand the tragedy is what the court is saying. But he was unsupervised when he made his way into the pool, correct? Marisol's attorney. Well, he started out, he's never going to admit it. Okay, I'm just letting you know that. He started out supervised. There was an adult in the kitchen with him. Now, the court says, who was not paying attention to him. According to what my recollection was, she was not paying attention. She was on a cell phone and was not paying attention to the child. I told you it gets worse. The child made his way into the pool, and the attorney says, okay, well, yes, that is correct. Are you suggesting the court says that he was being supervised and this adult allowed him to go into the pool? You're saying that's supervision. And he's saying, no, I'm not suggesting the adult allow him to go into the pool, but I'm not, he's saying the same thing you're saying. She was, so he was unsupervised, the court says. No, I'm not suggesting either, and I don't want the court to make the assumption that there were no adults around, that the court could care less about the fact that there was an adult there. The fact of the matter was totally without, and then court says, let me stop you there for a minute. Any adult supervision, he just kept on going. The court said, let me stop you. He just kept on talking. Don't do that.
Yeah, they do that though. They do. They just talk
He
over.
did that. He kept doing that. And so the court just kept going. He said, there's a difference between no adults around, there were adults around, and adults paying attention and supervising the child. There was no adult supervising the child, Jonathan, when he made his way into the pool, correct? Okay, all of this to say, the court is, let me see if I can get to a place. And he keeps going on because he thinks it's going to a jury. I'm assuming that he should know by this time summary judgment is going to be granted, and we're not going to make it to a jury. But he keeps saying the jury is going to have to answer in this case, and the judge is like, you're not going to get to a jury. You just keep.
So I thought when summary judgment happens, you don't go in front of the judge. So you do go in front of the judge? I thought it was just like the judge looks at the case and makes a decision.
You have a hearing. You have a hearing on the motion for summary judgment, yes. This is just one of those cases where there was a transcript of the hearing, so now I can show you what happened at the hearing. So yes, there is always a hearing on a motion for summary judgment in front of the judge, and the judge looks at the case and the evidence. He's saying to the attorney, he said, "You're not answering my question." The attorney does not want to answer the question. He said, and it's the absence of any kind of safety device which would alert. This is what the attorney just keeps going on. And the court is like, okay, with respect to warnings now, are you suggesting the warnings are inadequate? And then he says, the court says, you agree that the warnings start with the words danger, used only under competent supervision. And the court said, isn't it also true that the mother recognized the dangers? The mother recognized the dangers. So what more warnings are you suggesting Walmart should have placed on this product? If the mother recognizes the dangers and the warnings are there, and the fourth line says never leave young children unattended, what more terms of warning issue, what more should Walmart have done? And he wants to start talking about the expert. The court says, no, we don't want to, I don't have time. He says, the court says, give me your best legal authority for that proposition. See, he wants to make a legal argument here that the warnings were inadequate, but he never cites any common law for the court. He never goes in like the people did in the one case where they didn't even have a case, but they brought in the turntable case and said, look, Judge, here's a turntable case. And the judge says that case does not apply. But at least they brought a case. He never brings a case. The judge says, do you have a case, Mr. Rooney? Well, we have the laws of product liability. Do you have a case? Do you have a case standing for that proposition? Never does he does not have a case. Okay. So at the end of the day, the fact of the matter is that the argument of Walmart is that they had no duty because this product was not intended for the person that used the product. The product should never be used by somebody under the age of 36 months. The child was 15 months. You all right with this? Okay. So, but let me, okay, so I'm gonna get to the end of this and just say, I'm not gonna even go through all of that because we're short on time. But I will go on the current slide. And show you that the court, and now this 9th day of May 2011, it is hereby ordered that the judgment is entered in favor of defendant Walmart stores. Okay. And so I'm going to ask a question here. Let me get set up first. Okay. Do you agree with the judge's decision to grant Walmart's motion for summary judgment dismissing Maldonado's claims? Oh. Well, I know who B is. I know who that is right there. I know who said no. That's all right. All right, I have one more question. Hold on. Somebody. I have somebody that usually do that. Okay. What about this? What about this question? Do you think Maldonado received any recovery from Walmart? Let me see what y'all thought about that. So, what were the answers? A for yes and B for no. 70% said no. Let me see. Go back to this. Well, at some point, even though the court granted Walmart's motion for summary judgment, her attorney appealed. And I'm assuming because of it was really a horrible situation. Walmart ended up settling the case. So she did get some nuisance value, I'm sure, for that. And she might have got settlements from other people too, yes.
Why is it cases like with Starbucks where people get burned even though there's warnings on the cups that they still get like money? Is that like the company's decision? In some cases it is, but you can't have just indiscriminately hot water. I mean, you know what I'm saying? They better make sure that the water is a reasonable temperature. Yes, ma'am.
I read on Facebook, now it's probably not like a very valid source, but that there's going to be a class action lawsuit against the manufacturer of that bump stock for the big.
Oh yeah, I expect that.
Similar for like the strict liability and all
Yes,
that.
absolutely, yes. And if I were them, even though if I were representing the bump stock people, I would tell them, you better hurry up and sell as many as you can so you can have enough money to pay your attorneys and to pay off the judgment, because they're going to get poured out. Most, like, see, Walmart, they will be self-insured. And some of these other companies, they may be self-insured, but a usual insurance policy, because see, an insurance company is going to be paying this money. And the normal policy is going to have $1 million, but then there's going to be an excess carrier that's going to have a $10 million. So usually when you have a case like this, the underlying policy attorneys and the excess carriers come in so that they can assess the situation. And the excess, this is going to go into the excess.
It's like 10,000 people.
Yeah. It's going to go into the excess carrier. So, they're selling a product. I mean, come on. It can shoot out 600 bullets in 10 seconds. I mean, come on. Even though the ATF, allowed this to be, they can expect to be sued heavily. So,
Can they sue the government for not regulating the product?
I expect somebody is going to try this. I expect that. You cannot, there's something called sovereign immunity. We may get into that in this class. So you cannot go around suing the government. But there are some exceptions to that. I'm going to be watching this. I'm going to be watching that.
You can start a bill.
I'm going to be watching that, because who allowed that to... it's not like it's something that people didn't know about. They knew about it. The government knew about it.
Yep.
So,
Well, instead of doing the apprentice, next time we can do like mock trial for that trial.
yeah. Oh, is that what you want to do?